विद्यार्थियों, let us start solving the questions of Indian Evidence Act. First of all, this quotation we read, जब थक जाओ आराम कर लो. जब थक जाओ आराम कर लो, तो आराम कर लो, लेकिन कभी हार मत मानो. When you get tired, you take rest, but never you accept your defeat. Never you accept your defeat. It means work, continuous work. This is the secret of winning the race of the jindagi, of the life. Okay, start. Confession made before which of the following is not acceptable? It means if a confession is made any of the officer, before any of the officer, such confession shall not be acceptable. Such confession shall not be acceptable. When made before a magistrate in fear of police. Yes, it is acceptable, because the statement is given before the magistrate. Whether the statement confession is made in the custody of police, but it is made immediate presence of the magistrate, such confession shall be acceptable, shall be valid. So the first one is correct. When done before a magistrate and pressure from family member, no, it is also acceptable. When made before a magistrate in the presence of police, yes, it is acceptable. When the doctor is taken away from the police officer has been, it means if such confession is made before the doctor in presence of the police officer, such confession shall not be acceptable, because at that time the police officer was present there. At that time the police officer was present there. In this case, the correct answer of the question 1 is D. The correct answer of the question is D. Answer D. Option D is correct. Under Section 27 of the Indian Evidence Act, the fact discovered means, what does it mean? What does fact discovered means? The object produced only. The place from where the object is produced only. The object produced only. Fact discovered means when the offender was arrested, by the police officer, and before police officer he confessed his offense and said that such weapons were hidden in there and there, and that fact that weapons were discovered by the police officer where the accused had mentioned the place. At that place, weapons were found. Weapons were discovered of. It means the offenders were arrested and then confessed his offense, their offense. After their confession, that person told that some weapons were hidden other places. It means he told the name of places, and such weapons were discovered also. Such weapons were discovered later on by the police officer. The fact discovered. It means after confessing his offense, what the offenders, criminals said are stated before the police officer, in the custody of police officer, about the places, about the weapons, those are used by the offenders during commission of the offense. The such fact discovered, the object produced only, the place from where the object is produced. Object is produced. The knowledge of the accused as to the object and to the place. Yes, the discovered means the knowledge of the accused, knowledge of the accused as to the object and the place. It means in the case of Devman Upadhyaya, the Supreme Court said that the accused should be arrested and then accused confessed his offense or have produced statements about the knowledge of the information, knowledge of which, of the weapons, of the places, of the offenses which they have committed, which they had committed, about those offenses, about those weapons with which he committed the offense, and now he hit that offense, hit that weapons. The person accused said all these knowledge about the offense to the police officer. When he was in the custody of the police. So, see the correct answer of the question. The knowledge of the accused as to the object, and the place. It means object means anything about that the accused told to the police officer. For example, weapons, for example, lathi, stick, knives, etc. So C option is correct answer. Which section of the Indian Evidence Act deals with doctrine of confirmation by subsequent facts? Yes, Section 27. The accused firstly arrested by the police officer and before and in the custody of police officer, the accused said about the offense which he had committed, about the object, about the knowledge relating to the offense. All these informations are given to the police officer. So, and these information leads to the police officer to the fact, to the object. It means the statement was given by the accused, and if the accused says anything about the weapons, about the things that was used in the offense, and later on those weapons, those things are discovered by the police, it means doctrine of confirmation. It means the statement was given the police officer, and later on the statement was confirmed by the facts. Those are found by the police officer later on. So section 27. So the section 27 is relating to the doctrine of confirmation by subsequent facts. This is the correct answer of the question. Section 27. Police effected the recovery under the section 27. Police effected the recovery under the Section 27 of the Indian Evidence Act. Indian Evidence Act 1872, before recording the formal arrest of the accused, such recovery shall be legal, lawful under Section 27. So the correct answer of the question A. The correct answer of the question is A. Yes. Next question 5. Confessional statement of the accused in custody when admissible. When such statement is admissible, it means a confessional statement of the accused. A confessional statement of the accused in custody, it means in police custody. When it admissible if relates to commission of crime by himself. It means the person who offers his confessional statement, he himself produces such confessional statement. That person by himself. Next, if relates to commission of crime, if relates to commission of crime only by the co-accused, leading to discovery of a fact, relates to preparation of crime? No. The correct answer shall be C. Confessional statement of the accused in custody when admissible, when such statement leading to discovery of a fact. Yes, Section 27. It means the statement was given in custody of police officer and later on what were said about which things were mentioned by the accused during producing the confessional statement by the accused before the police officer. Later on, these things, these weapons were discovered also by police officer. In this case, such admission or confession shall be relevant, shall be admissible also. If any statement is given before police officer in the custody of police officer, any statement is given in the custody of police officer and later on if any part of the such confessional statement is discovered by the police officer, only that part of the confession shall be admissible, shall be admissible. So C option is correct answer. leading to discovery of a fact. It means when such part or any part of confessional statement is discovered by the police officer later on, subsequently, such part of the confessional statement shall be relevant. So the option C shall be the correct answer of the question 5. Option C shall be the correct answer of the question 5. Next question. If an accused voluntarily consents for brain mapping, voluntarily consents for brain mapping and narco analysis, then such information is relevant under which section of Indian Evidence Act? Under which section of Indian Evidence Act? S. The person, the accused voluntarily consent for brain mapping, narco analysis. The accused was ready for these acts. If voluntarily he was ready, the accused was ready, it means such information is relevant under section 27. Yes, because it was confirmed by subsequent discovered fact. So the correct answer of the question shall be section 27. 27 is the correct answer, because the accused voluntarily was ready. The accused voluntarily was ready. Consents for brain mapping. It means he was ready for brain mapping and narco analysis. And if any information is found from brain mapping and narco analysis, any information, such information shall be relevant under section 27, because the accused was ready for these acts, for these tests. So such fact shall be relevant under section 27. The correct answer of the question shall be C. Next question. During the course of trial of a murder case, which of the following may be proved? If the case, murder case, which of the following may be proved? Statement of confession of accused made in police custody during investigation. Statement of confession of accused made in police officer, made in police custody during the course of trial of a murder. Which of the following may be proved? If any statement of confession is given by the accused before the police officer in the custody of police officer during an investigation, it is under 27. Any confession if made by the accused in the custody of police officer shall be irrelevant under section 27. Sorry, 26. Under section 26. 27 says that immediate presence. 27 says that if the fact about which the accused said, if discovered by the police officer, the discovered fact, discovered information, it means such information that is confirmed by the discovered fact shall be relevant, and other part of the information shall not be relevant, shall not be admissible under section 27. The statement of confession of accused made in police custody during an investigation shall be irrelevant under section 26. Recovery of the weapon of the offense on the basis of a statement made by accused during an investigation of another case. Yes, this is correct. This is correct. Correct answer. B is correct. Read again. Recovery of weapon of offense. It means such weapons were discovered on the basis of a statement made by accused. It means those statements those are given before the police officer in the custody. It means if any accused makes confession in police custody during an investigation on the basis of such statement, if police discovers weapons, it shall be relevant, admissible under section 27. Yes, B is correct answer. After recovery of dead body, after recovery, the statement of accused as to place where he threw the dead body. It means the statement of accused. It means firstly the body was recovered and then the statement was given. It is not in accordance with the section 27. According to this provision is not to the provision of section 27. So the correct answer of the question shall be B. B is the correct answer. For the provision of section 27 of the following does not come under the category of police. It means under following which is not in the category of police officer, who is not known as a police officer. Raj Kumar, in the case of Raj Kumar Karwal, name of the case Raj Kumar Karwal, versus Kripa Mohan Vishwani. Kripa Mohan Vishwani, Raj Kumar Karwal versus Kripa Mohan Vishwani. In this case, it was held that police officer, custom, for example, custom officer, railway force, NDPS, member of NDPS, these officers shall not be called, shall not be regarded as police officer. So, according to the case here, Police Patel is a police, watchman is also a police, excise officer, police, member of railway protection force is not a police force, because in the case of Raj Kumar Karwal versus Kripa Mohan Vishwani, it was held that member of NDPS, railway police force and custom officers shall not be regarded as police officer. But so, correct answer of the question shall be D. D is the correct answer. The basic idea embedded. The basic idea embedded in Section 27 of Evidence Act is the doctrine of. It means which doctrine, which of the doctrine is embedded in the Section 27. Yes, the doctrine of confirmation by subsequent events. This theory was laid down, propounded in the Section 27. Section 27 says that if any confessional statement is given before police officer and later on the facts were discovered by the police officer, it means what statements, what information was given to the police officer later on confirmed by the discovered fact. So, confirmation by subsequent event means facts, discovered fact. The statement was given before police officer and later on it was discovered, the fact was discovered or confirmed by facts discovered. This principle is propounded in the Section 27. So the correct answer B. Next question. Section 27 of Indian Evidence Act 1872. Which statement is false? Which statement is false? the person giving the information must be accused of an offense. It is said in the case of Dioman Upadhyay versus state of UP. The statement was said. The statement was said. Second, he should be in police custody. It is also mentioned in the case. It means Dioman Upadhyay, in the case of Dioman Upadhyay versus state of UP, the Supreme Court told that the accused must be in the custody of police officer. The person giving information must be accused of an offense. Yes, it means the person who giving information in the custody should be in the custody of police officer and should be an accused also of that offense about which he is giving information. So the first option is correct. Second is also correct. Next, any relevant fact to be ascertained on the basis of information, given by that, it is also true. So here the question is section 27 of the Indian Evidence Act, which statement is false? No statement is false. No statement is false. It means all statements are correct. So the correct answer of the question is D. D is the correct answer. D is the correct answer of the question. Okay. Next. Yes. Thank you a lot for watching this video. Okay, thank you. That's all.